To please the court, we're before the court this afternoon in the matter of the State of Ohio versus Catherine Belcher, case number 25 CR 1154. The defendant is present in the courtroom with her attorney, Rachel Smith. We're before the court for purposes of sentencing, the defendant having pleaded guilty and been found guilty of 1-count felony of the 3rd degree aggravated possession of drugs, 1-count felony of the 5th degree possession of cocaine, 1-count felony of the 2nd degree robbery. Parties are ready to go forward, Your Honor.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Ms. Belcher is asking the court to impose a minimum prison term here. Ms. Belcher appreciates the seriousness of the injuries that her mom suffered as a result of the instant offense. Ms. Belcher acknowledges a long history of drug abuse and difficulties conquering that. Although she has struggled in the past, this is her first felony conviction. She's never been to prison before. Ms. Belcher is aware that her acceptance of responsibility and show of remorse perhaps did not come through as clear as intended to her pre-sentence report, and she does have a letter here to read to the judge today.
Thank you. Ms. Belcher, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. Firstly, I would like to thank Lake County officers, the Sheriff Department, and you, Judge Collada, for granting me a moment to sit and reflect on my mistakes. At first, I didn't understand, but God has granted me the new vision to see my life through a different lens. Because God placed you into my life, I didn't go septic and die in jail. Thanks to the jail and sheriffs for transporting me each week, I have my health back. Thank you so much for this, Your Honor. I've been selfish for many years, allowing my addiction to completely take over my soul, and I realize now that my actions were so selfish. I genuinely would like to apologize to my family and friends, and mostly my mom, because she's all I have. My dad, after my dad passed, I have not only let myself down, but my children. I think today was the first selfless act I've done. I asked them not to come because I didn't want them to watch their mother or cause any of them any more pain. I feel deeply. It just wouldn't be right. My heart would completely break for them to have to watch me go to prison as well. I will absolutely do every ounce of time God sees fit for me to do. Your Honor, I come to you today with an open heart. I trust that you will grant me understanding with hopes that you see fit, that one more opportunity is granted so I can fix this and show not only myself, but my family and you that I am bigger than an addiction, and please give me one more chance. Thank you so much.
Thank you. Shapiro for the State of Ohio.
Thank you, Your Honor. First, I'd like to, pursuant to the agreement between the parties, that the court order that the defendant pay $100 restitution to Mr. Robert Taylor, Taylor. This is an agreement that between the State of Ohio and the defendant. This is a car that the defendant struck that night, caused some damage. This is Mr. Taylor's deductible. The state dismissed count 16. It's a misdemeanor in the first degree with the understanding that that would be ordered. So we would ask that the court please do that. Defendant has a drug problem that she has never dealt with, and that exacerbated the offenses here. Maybe it's the root of it. I don't know. Looking back at her criminal history, she has a domestic violence from 2001, and so she does have something other than drugs in her past. I mean, she has a misdemeanor drug offense as well, but some theft charges. These are convictions that are common to people who are convicted to drugs, who steal. But the defendant's 39 years old, hasn't gotten any help for it, and it culminated in her robbing her mother. She was a 71-year-old elderly lady. Whether she was drinking that night or not, she didn't deserve to be robbed and pushed down and get broken ribs. The injury in this case is serious. And I think that differentiates this case. Yeah. Criminal history, well, there's no felonies, there's a pattern of. The state believes that a overall conglomerate sentence of 5 years is an appropriate number of years for the court to impose on the defendant for all of this conduct combined, Your Honor. The defendant does have credit for 93 days. The state would ask for, pursuant to the agreement of the parties, forfeiture of all of the contraband drugs that were taken in the packaging as by agreement.
So that is just drugs and paraphernalia we're talking about.
Yeah, there was some items that.
But no other property, no phones or money or anything like that.
There was some other stuff that was recovered. Yeah.
I received a victim impact statement. I've considered what's been said here in court today by Ms. Smith, the defendant, statement that she read, the prosecutor, the recommendations from the parties. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 29, 29, and 11 of the revised code. For the factors in 29, 29, 12, in regards to count 1, I am going to note that the defendant's son was in the vehicle with her when these drugs were found and the pipes were found. That makes it more serious. And the son's an adult. I don't want to mislead it. It's a minor, but nonetheless, it's a 20-year-old son in the car with her. No other factors are present regarding the offense being more or less serious in regards to count 1. In regards to count 9, the court finds that the defendant's relationship with the victim facilitated the offense. This was her own mother. That the victim suffered serious physical harm, and that injury she sustained was exacerbated due to the age of the victim being 71 years old at the time. As for recidivism factors, the court finds the defendant was on probation at the time she committed the offense. There's a history of criminal convictions, albeit no prior felonies, but a lengthy history of criminal convictions. She's been on probation before in the past. She's violated her probation on multiple occasions in the past, so she has failed to comply with previously imposed sanctions ordered by courts. And every factor is present indicating recidivism is more likely. There's a drug abuse problem that relates to all 3 offenses, and she hasn't done anything to address it. As for the robbery charge, there's no genuine remorse. None. In fact, she basically denies doing it. When she met with the probation department, she told the probation officer, and this is a written version, that she's scared that her mother might have fallen down the stairs and is embarrassed to say anything, and that's how she got injured. She then told probation that she denied ever hurting her mother, said she only grabbed her wrist and pushed her out of the way so she could leave. She indicated she's okay with doing time for something she did, but does not feel she's done anything and she's being, quote, railroaded in this case. And she's taking it, those are her words, so her mother doesn't have to go through this anymore. There's no acceptance of responsibility in terms of the robbery charge and what she did to her mother.
I was going.
What's that?
I wanted to apologize. I was going through a lot.
You're going through a lot.
Hearsay. I was told my kid's father passed away, and I was going through some stuff, and I didn't get to finish my pre-sentence report.
You finished your pre-sentence report. It's completed.
No, I didn't get to write everything. That I was fully accepting my mistakes, that my addiction caused whatever circumstances happened.
Who prevented you from doing that?
No, I was not being myself.
So you were given the opportunity to do it.
I know, and I wasn't doing it right. I wasn't being truthful, and I was just angry. And this should have never happened.
It's been 180 days in jail so far. It wasn't like you were still under the influence of anything when the time this is going on.
No, I meant for my addiction affected the relationship between me and my mother and the outcome should have never happened.
I understand that. I'm saying that when you met with probation just within the last month, you still didn't accept responsibility. You still blamed your mother. You said it was her fault, or she may have fallen down the stairs and hurt herself. You didn't do anything. Now, the day you're sitting here waiting judgment on what's your future, what's going to happen, is the first time we're ever hearing anything that you're saying you did something and you lied and that you are responsible. Well, I don't accept that.
Okay.
When you're sitting before the judge who's about to pronounce sentence, and that's the first time that you come forward accepting responsibility, when you had multiple opportunities before to accept responsibility and you didn't do it, that's not genuine remorse. This is your own mother. Even with the drug charges, you don't accept responsibility. You say it's all the person that was in the car with you. He's putting it all on you. You admitted in the other drug case having heroin but denied the methamphetamine and all was yours. I mean, they're just denials. So every factor indicating recidivism is more likely is present. There's no factors present indicating that recidivism is less likely. 9 are subject to a presumption for prison. The presumption is not overcome. No way the court can make any finding that the factors indicating recidivism is less likely outweigh the factors indicating it's more likely. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to available community control sanctions. Therefore, it will be the sentence of this court. And count 1, defendant serve a term in prison of 12 months. Then count 6, defendant serve a term in prison of 9 months. And then on count 9, defendant serve an indefinite prison term of a minimum of 5 years, a maximum of 7.5 years. The 3 counts will be served concurrent with each other for an overall aggregate of an indefinite term of a minimum of 5 years, maximum of 7.5 years. She has credit for 93 days. She's already served. Those will be granted to her. Order the forfeiture of the contraband and instrumentalities, the drug-related paraphernalia and drugs themselves. All the remaining counts of the indictment will be dismissed pursuant to the agreement. I'll order restitution as agreed to Robert Taylor in the amount of $100. I need to advise you upon your release from prison, you will be placed on post-release control. It's mandatory for at least 18 months. It could be up to 3 years. While on post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. And there is a rebuttable presumption that you will be released from that prison term after you have served the minimum sentence that I imposed, the 5 years. Now, while there's a rebuttable presumption, that doesn't mean it is guaranteed. If while you are in prison you misbehave, you don't follow the rules of the institution, you remain a threat to the community or others, you're not sufficiently rehabilitated, the prison officials can schedule a hearing, which you'd be entitled to be at. And at that hearing, if they demonstrate that in fact you aren't sufficiently rehabilitated or remain a threat or committed violations of the rules, they don't have to let you out at that point. They can keep you in prison. They would select a new date that you'd be released with the presumption that you'd be released on that new day. And you would have to be released on that new date unless, again, you continue to misbehave, remain a threat, not be rehabilitated. If that was the case, they'd postpone the release date again. Under no circumstances, however, can you be kept in beyond the maximum sentence. So even if you misbehave the whole time you're there, they have to release you at the end of the maximum sentence. Thank you.
All right.
Miss Amy Lou Husted is at the podium. She is Deputy Director of the Public Defender's Office, along with Miss Lily Ballad, defendant in this matter. The people are here and represented by their elected prosecutor, Mr. Scott Kerner, Agent Rolfe from the Michigan Department of Corrections. On December 18th of the year 2025, Ms. Lilybed pled in this courtroom to count 4 possession of methamphetamine and count 5 assault and battery. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report along with the sentencing information report. I received a report from pretrial services. She's completed the program successfully. I also received a sentencing memorandum from Ms. Houston, and I've read and considered both of those documents. Ms. Lilybed, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. May put your hand down. Ms. Lilybed, did you have a chance to review the pre-sentence investigation report?
Yes, I did.
Any changes you'd like to see made to the body of that report?
There are 2 minor changes, Your Honor, that I outlined in my sentencing memorandum. Do you want me to place them on the record, or?
Yeah, you should. You should, if you would, please.
So they hit the MDOC attached an older
It did.
PSI, and
Yes.
in that we need a couple of things changed. First, under the marriages, in the table, the children's boxes should say at the time the old one was, it had the ages at the time the old one was written.
Either Rolf?
Your Honor, it's my understanding that if it already went to court, we're not allowed to change a prior pre-sentence report.
But it's attached to our report, and they didn't. Aren't you like?
And see what they.
There you go.
I mean, my understanding was it's attached because like they didn't include from the family marriage history part in the new report.
I see your point. Give it a shot, Agent Rolf. See what happens.
Yes, Your Honor.
Do you have any scoring challenges, Mr. Kerner?
Yes, Your Honor. There's no challenges to the PRVs. However, the people who challenge OV15, we believe that should be scored at 5 points because of the paraphernalia, the scales, and the baggie that preponderates towards delivery.
Ms. Houston, your response?
Your Honor, my client indicates she was not selling or using the drugs. So, but I would leave it to the court's discretion.
Yeah, I know that might be her position, but when they searched her grandmother's car, law enforcement found 2 digital scales, multiple empty plastic baggies, and over 7 grams of methamphetamine. And so the court finds that those factors preponderate towards a delivery component, which warrants 5 points in OV15. So that challenge should be sustained. Any other challenges, Mr. Kerner?
No, Your Honor.
Ms. Houston, do you have any scoring challenges?
No, Your Honor.
Ms. Houston, add them up. I'm sorry, Ms. Rolfe, add them up.
Your Honor, the PRVs remain the same at 27, level D. Offense variables, total 5. OV level 1, and it remains at 0 to 17 for guidelines.
Okay, thank you. 0 to 17. Allocution, Ms. Houston.
Thank you, Your Honor. Your Honor, in this incident, my client was arguing with her teenage son, and he hit her, so she hit him back. She then left the residence and then had police contact because he called the police. Your Honor, she regrets her actions on that day. She knows that she certainly could have handled the situation much better. She's the adult, and she should have, stepped away from the situation rather than let it escalate to them becoming physical with each other. Your Honor, she has drug addiction, and she also has some mental health issues. She needs treatment for both of those. She knows that. She knows that she's just going to end up back here again and again until she gets the proper treatment. She has done very well on pretrial services. They gave us a report saying that she's had successfully completed it. I do note that the recommendation is for her to serve 6 months subject to waiver for inpatient treatment. However, since she has done so well on her pretrial services, we would request that I know Your Honor is aware that our office works with clients and we can help get them into the inpatient. So we would already done so if it weren't for the fact that she had this hearing date. So we would ask that she be left out of jail and allow our office to get her sent into an inpatient program we can call Midstate with her and make that happen.
Thank you, Ms. Houston. Mr. Kerner.
Thank you, Your Honor. This is the defendant's second conviction for drugs. I'd ask the court to fashion a sentence that focuses on punishment deterrence and rehabilitation, Your Honor. Thank you.
Thank you, Mr. Kerner. Ms. Lilybed, what would you like to say?
I'd just like to apologize to the court. So I had a relapse in the drug use, and it's not something that I want in my life. It's ruined it. So if I just ask for discretion and hope that you can believe that I can do the right thing.
That I do the right thing?
That I do the right thing.
Because I assure you, I will do the right thing.
Yeah.
Thank you. So I go back to the last time you were here on possession of methamphetamine, and that would have been in 2024. And on March 15th of the year 2024, you said to me, you said, I have no desire to smoke. I'm cleaning up my life for my 2 children. That's what you said.
Yes, sir.
So I believed you. I bought it, hook, line, and sinker, and gave you an opportunity to have that felony taken off your record, and you didn't do it. You failed. You ultimately successfully completed probation, but you didn't get to 7411, and you got that conviction on your record. So move forward 2 years, almost 2 years. Here we are again, and this time it's much worse. I don't agree with the way your attorney characterized the incident, and the transcript of your plea doesn't either. You went to the apartment complex where your teenage son was. You were trespassed from that. You weren't allowed to go there, and you struck him. You struck him. And we called the police. You were pulled over driving your grandmother's car with your daughter's 8.
Yeah.
She's in the car with you. And here's what law enforcement finds. A zip-up bag was sitting between the driver's seat and center console within reach of the juvenile. The bag was open and observed there were 2 digital scales, a plastic bag which contained suspected meth, another small plastic bag inside the plastic packaging, a pack of cigarettes that contained suspected meth, a glass tube with a silver lid that contained suspected meth, several small empty Ziploc bags, and a tube labeled Skittles. The tube contained a syringe with brownish colored liquid inside suspected to be heroin. There was also a glass pipe with a dark residue. All in reach of your 8-year-old. And I'm telling you, 8-year-olds know. And I'm sure that 8-year-old knew exactly what you were doing and what you had. So did your 15-year-old for that matter. And you had over 7 grams of methamphetamine, which indicates to me that you're probably dealing drugs. So you had your chance of treatment with this court, and you didn't do so well. And this court is going to focus really on protection of society, namely your children, from you. There'll be some financial obligations you'll need to meet with us, Ms. Lillyblad. That includes a crime victims assessment in the amount of $130, court costs in the amount of $961. DNA fee? No DNA fee. We'll strike that. That's paragraph 40. And then a $118 state cost. And Ms. Lillyblad, you will receive a sentence to the Michigan Department of Corrections where you'll spend a minimum of 17 months, not to exceed 120 months. Against that sentence, you'll receive credit for 85 days. Agent Rolfe and Ms. Lillyblad's packet, please include a directive that she undergo substance abuse and mental health evaluation and follow the recommendations.
Yes, Your Honor.
Ms. Lillyblad, you have 42 days from today's date to request an appeal. If you'd like appellate counsel to assist you, you've got to make that request within that time. If you would initial the form acknowledging that you received the notice. Mr. Schmidt, best of luck to you, Ms. Lillyblad. Bill State of Michigan versus Corey Mrazek. Mr. Mrazek was last before the court on January 26th of year 2026. On that date, the court had advised Mr. Mrazek that his status on probation was in question because his agent made an allegation that he violated probation, namely using methamphetamine. Ms. Houston, did you have a chance to talk to Mr. Mrazek about these allegations and his right to have a hearing?
I have, Your Honor.
How would you like to proceed?
Your Honor, it's my understanding my client's going to plead guilty.
How do you plead then to the allegations that you violated probation?
Guilty, sir.
What'd you do that makes you guilty, Mr. Mrazek?
I violated by reporting the probation with a cotton swab of methamphetamines, of using methamphetamines.
You use methamphetamine?
Yes, sir.
And you use that on purpose?
No, sir.
Yes.
Oh, yes, sir.
I mean, it wasn't an act, you didn't just fall and accidentally ingest it.
No, sir.
So
Nobody
it was an
forced me
intentional
to
act
do it. Nobody forced me to do it.
It was an intentional act to put that chemical into your body, correct?
Yes, sir.
All right. And you knew that that would violate your probation if you were caught.
Yes, sir.
I find you guilty. Wait a second, we don't have a probation agent here.
Oops. Sorry.
Let's take a recess. I'm all about moving early when we can. The hearing's set for 10:30, and we just can't. It's not fair to proceed without the Michigan Department of Corrections. So we're going to take a recess and wait for them.
Okay. Sorry, Judge.
It's okay, no worries. State of Michigan versus Corey Mrazek. The case was not scheduled to be called until 10:30. Ms. Houston was very excited and wanted to go early, and we all ran in here and got together again and got on the record, and then the court realized that Ms. Hertel was not here from the Michigan Department of Corrections. You can't be in trouble for not being 15 minutes early. That really isn't your fault. And I said, well, time out. Let's take a break and wait for the Michigan Department of Corrections. It wouldn't be fair to proceed without them. She's here now. Thank you. Sorry about that. And what you missed, Ms. Hertel, is Mr. Mrazek had just pled guilty to using methamphetamine, which would amount to a violation of probation. Is that correct, Mr. Mrazek?
Yes, sir.
You, Ms. Houston, allocution.
Thank you, Your Honor. Your Honor, Mr. Mrazek has a drug problem. He has been struggling with it. He has been sober he's been able to achieve some amount of sobriety. He unfortunately had a relapse that resulted in this probation violation. Your Honor, we respectfully ask that you follow the recommendation of the MDOC in the report and also continue so that he can continue with his treatment for his addiction.
Thank you, Ms. Houston. Mr. Kerner.
We'd leave it to the court's discretion.
Thank you. Mr. Mrazek, what would you like to say?
I would like to continue my rehabilitation, sir, and continue with the probation and further no longer use methamphetamine so I can better myself, so I don't have to come back in here or go to the Department of Corrections, sir.
Is there anything else you'd like to say?
No, sir.
Thank you. So I'm reviewing the probation violation report, and there's a lot of troubling factors. You were released from jail, called and said that you couldn't make it, you were in an accident. Come to find out you weren't in an accident, and your girlfriend reported that you were smoking methamphetamine in the parking lot of the Michigan Department of Corrections. I've never heard of a thing like that before. Who would use methamphetamine in the Michigan Department of Corrections parking lot? Well, in any event, you clearly demonstrated to the court that you're not interested in treatment and you're not interested in probation. So the court will discharge you from probation. Your probation will be deemed unsuccessful. To the extent you owe fines and costs, those will be reserved. We'll use our civil remedies to collect those, and you will receive a sentence to the Michigan Department of Corrections, Mr. Mrazek, where you'll spend a minimum of 15 months, not to exceed 240 months. And your credit will be 208 days. And Ms. Hertel, please include in Mr. Mrazek's package to the Michigan Department of Corrections a direction for him to undergo a substance use evaluation and follow recommendations. Listen, this is not a life sentence. It's not a very long sentence at all. But what it is, Mr. Mrazek, and what I hope is that it's a shakeup for you to understand that you got to change. You got to change. You're going to kill yourself, or you're going to kill someone else. It's going to happen. It's too much. It's going to fry your brain up, and then there'll be nothing left of you.
Yes, sir.
So take this as an exercise, get some treatment. You're going to see what's waiting for you, because what's waiting for you ultimately is either the cemetery or a life sentence.
Yes, sir.
If you don't stop. That's it. It's not a long sentence, but I hope it's enough for you to have an eye-opening experience that, hey, I don't want to die, and I don't want to go back to prison. That's enough of that. I don't want to do that anymore.
Yes,
so hopefully it'll be a positive learning experience for you, at least to the extent that you'll never want to go back again.
Yes, sir.
You have some appellate rights. Mr. Schmidt's approaching with them. What I'd like you to do, sir, is initial the form acknowledging that you received the same. If you'd like appellate counsel to assist you with the appeal, you've got 42 days from today's date to make that request. Thank you all very much.